In this video, we'll continue step 4 of the legal research process, expand and update. So we just covered expanding using headnotes with classification systems and citators, and now we're getting to updating. So you've got a case and it's relevant and it helps your argument, but you can't use it unless you first make sure that it's good law. That case that you want to cite was published and then frozen in time. But later cases come along and maybe they've overruled or reversed your case, criticized your case. Maybe they've affirmed or followed your case. And even the legislature may have acted to override your case with a new law. So researchers need a way to discover what happened after their case was published. And luckily we have one. The process is called updating a case, though in practice most people call it shepherdizing. And the citators are the tools that we use to help us do it. So both Lexis and Westlaw have developed their own citators, which are available on their platforms, of course. Lexis is called Shepherds, and this is where we get that term shepherdizing. Westlaw's citator is called KeyCite. Nearly every case in these two platforms are assigned a flag in KeyCite or a symbol in Shepherds. So KeyCite flags look like these, and the further breakdown of negative treatment is there for you to review again on Brightspace. This red striped flag is fairly new on Westlaw. There used to be just the red one, no longer good law for at least one of the points of law. And you would have to go in and see whether or not it was still good law for other points of law that remain valid. But now they're trying to help you out by letting you see that ahead of time with the stripes. But of course, you still have to go in and see which point of law is overruled and which remains valid. The shepherd symbols come in these categories, and you can peruse them again on Brightspace. But notice that Shepherds doesn't have a red striped symbol. So when you see the red stop sign, just know that yes, it looks like one point of law is overruled, but there could be other points of law in there that are still valid. So maybe your point of law is still valid. And if so, you can still use that case even though it has a red symbol. But the only way to find that out is to read the case. And this is a point worth repeating. I just said that maybe you can still use a case even though it has a red symbol. How can that be? Well, think back to headnotes. All of those points of law in a case, there are often many more than just one point of law, right? And so you can have one point of law that's overruled and the other points of law left untouched or still valid. And you can still cite your case for those other points of law, even when there's a red symbol. So don't just make sure that you're not citing it, of course, for that overruled point of law, obviously. And so just because you see a red symbol, don't discard the case immediately. Go in and figure out why it's red. And the same goes for yellow symbols. Go in and figure out why it's yellow. Don't immediately assume that any case without a red symbol is safe to cite. There are some cases with yellow symbols that should not be cited. And that's usually very fact dependent. So you need to be very familiar with the issue that you're researching and your facts. And then you need to read why other cases have distinguished the case you'd like to use on facts, or disagreed with the case you'd like to use as reasoning, or declined to extend the reasoning, or maybe they declined to extend it to the extent that you were planning on using it for your argument. So if it's red, read it. You might still be able to use it. And if it's yellow, read it. You might not be able to use it effectively, at least. So keeping all that in mind, here are the 2 steps to the good law test. I know there's always so many steps in legal research. So step 1 is, what color is the flag or symbol? If it's neutral or positive, or even if there's no symbol, then the good law test is complete. You're done. But if the symbol indicates negative treatment, you need to investigate. And step 2 is that investigation. You need to think about what jurisdiction treated your case negatively, and do you care about that jurisdiction? Is it from a level of court that can bind you? Or not? And if so, then you keep going and you figure out what point of law was treated negatively. Is it the point of law that you want to use, or is your point of law still good law? Here's how all of that thinking might play out when you're looking at a case in Lexis. So step one, you notice a yellow symbol. Now, this is in the Ninth Circuit. There's no subsequent appellate history, so that means the case did not continue on to the Supreme Court. So we investigate this yellow, but how exactly? Where do we click? You can click on any of these options circled in green. There's a lot to choose from, and all of them will work except this one. Don't click the Y. It's tempting, but the reason why you don't want to click the Y is because if you do, you'll get a quick but incomplete answer. You want the complete picture, so don't be fooled into clicking the incomplete one. So as long as you stick to any of the green circled spots, you'll end up here in the Citing Decisions tab. All roads lead to here. Um, and you do your step two analysis. So what jurisdiction issued the negative treatment? And you can filter out the noise if you want to. Just show the negative treatment from the jurisdictions that can bind you. So here I've limited the negative treatment to just the cases coming out of the Ninth Circuit. But if you were in a California court on a state issue, you'd limit that differently. And then you still have a list of cases to examine, but you have another filter that you can apply to clear out some more noise. So figure out which head note you care about. Which head note is the one you don't want to be overruled, and limit to just the negative treatment of that head note. You don't care if the other head notes have been overruled. So here in Lexis, you can just eyeball the head notes if you want to. You can scan the list and see if the head note you care about appears. Maybe I care about head note 2 and I don't see it here. Right? So my conclusion is I can use this case. There's a yellow flag, but there's no negative treatment from my jurisdiction on my point of law. Now, what if I did care about head note 1? Well, then I'd need to look at the Whisk case. And you'd want to open Whisk all the way up, not just the blurb here, but go ahead and click open the case up and see all the negative things that the Whisk case has to say about Partington. And here's how you think through that good law analysis in Westlaw. So step one, you notice the yellow symbol. This is the Ninth Circuit, and there's no direct history to the Supreme Court. So we investigate this yellow flag. You can click the flag or you can click the negative treatment tab. All roads should lead to that tab. And you have here a list that's difficult to filter or sort. So this tab, the negative treatment tab, is just for browsing. And here there's just 11 things to browse. So you can scroll through them. You can check the jurisdiction of each one, Ninth Circuit, and you can check the head note that was given negative treatment. So we see those head notes here. But if that's too much, if there's more than 11 and you want to filter, you can use the tab for citing references. So get out of the negative treatment tab, use the citing references tab because it allows all of this filtering. So you can filter by jurisdiction, you can filter by headnote topics, and oh, it's cut off here, but treatment status, you can filter to negative treatment status. And then you'll get all the things that are here, but filterable. So if I say I care about head note 2, then I've got to investigate this case. So I'm going to click into that case, open it all the way up, and see the negative things that it has to say about Partington. So a few words of warning before we finish. The editors of Lexis and Westlaw are trying to make your life easier. They are. They're giving you shortcuts to your good law analysis. But be aware of alligators in the shortcuts. You are the lawyer. It's your behind on the line. So use those shortcuts like the most negative shortcut in Westlaw, the Y shortcut in Lexis. Use those with extreme caution. The best practice is to do the good law analysis yourself. Let the tools, those flags, those symbols, those filters, let the tools help you find the connections, but don't let them do the analysis. The AI isn't the lawyer, you are. Some announcements before we conclude. I will be unavailable for Zooming this weekend. So Professor Schultz, who taught you your orientation session, she's going to hold a study hall for you this weekend. She can only do it on Sunday. So if you need a study hall this weekend, come to her Zoom on Sunday. The details are going to be on Brightspace. She will be waiting, happy to answer your questions. And another announcement, this is our last module for a few weeks. Per the syllabus, you're going to have 2 weeks off to study for and to take your midterm. So after your graded assignment is due on Sunday, you will have no legal research until we resume with Module 6 in the week that begins with March 11th. And you're ready for the last part of the learning exercise. So go ahead and work through this. Do make it through each question. Don't make your answers beautiful or perfect. This is not graded. This is for you. Save your time making beautiful answers for the graded assignment that you're going to unlock after you upload this learning exercise. Okay. And that's it for me this week. I will see you in Module 6. Oh, and good luck on your midterm.